Hi, this is Lee from the Law School Toolbox. Today, we're thrilled to have with us Dean Jackie Gardina of the Colleges of Law in Santa Barbara and Ventura. Dean Gardina is a visionary in legal education dedicated to making it more accessible and affordable through innovative teaching and learning models. She's also deeply involved in shaping the future of legal licensing in California. Dean Gardina, welcome to the show. Thanks for coming.
Thank you so much for inviting me. I'm excited to be here.
So outside of the next gen and whatever's California's doing, we'll just talk about that in a few minutes.
Okay.
Other states are getting a little more creative. They are
Yeah.
creating new paths to licensure without a bar exam. I think Oregon is one of the states that has come up with something pretty quickly. I believe California just rejected this idea.
Mhm.
I saw your LinkedIn post about that. Thank you very much for
Mhm.
everybody should follow you on LinkedIn.
Thank
But
you.
you're welcome. But so, what's going on here? Like, why are some states considering it? Why does it seem that California is not ready to consider this? Do you think this is really kind of the next wave that's coming with this idea of a different bar exam?
I think that so let's talk about alternative pathways to licensure. Obviously, when we talked about the history of the bar exam, it didn't exist until 50 years ago in its current iteration. So there was always alternative pathways to licensure throughout history. So this isn't a new idea. But Wisconsin kept diploma privilege. So when there used to be diploma privilege in all 50 states, and in fact, that was considered the kind of the prestige of going to a law school when it wasn't required. You got diploma privilege versus those who studied for the law who still had to take the written exam. And so diploma privilege disappeared, but Wisconsin still has diploma privilege. And it offers a nice kind of study ground for what does it mean not to take the bar exam? Does it protect the public? Does it not protect the public? Are there higher instances of malpractice and ethical issues among those who receive diploma privilege versus those who sat for the bar exam? And the answer to that is no. So Wisconsin has been a study for us since diploma privilege existed. New Hampshire has had what they call the Daniel Webster program, which is a very specific set of courses and a program that if you go through it, it's been approved by the State Bar of New Hampshire and the Supreme Court to actually lead to licensure. You don't have to sit for the bar exam in New Hampshire. And that's been around for decades. And they came and spoke to the California the Blue Ribbon Commission on the future of the California bar exam. Oregon has just developed what's called a portfolio bar exam, which is a supervised practice pathway. And then Washington has indicated that it would like to move forward with an alternative pathway. And then Nevada has created a hybrid, which is about 100-question test followed by supervised practice after law school in order to kind of meld the two. And I think that's be interesting. So when we talk about laboratories of democracy or laboratories of autocracy, depending upon your viewpoint of states right now, I think it's going to offer us some really interesting insights. And we've got smaller states like Wisconsin that has 2 law schools, or like Oregon that has a limited number of law schools, where they can experiment without the bureaucratic nightmare that it would be for a state like California that has 50 law schools and 10,000 people sitting for the bar. So there are challenges in California that don't exist in states that are much smaller, but we can learn from them and find out more about how they're working. I think what excites me about it is that right now it feels like the bar exam tail wags the law school curriculum dog, and I am preparing people to sit for a bar exam and not preparing people to practice law. And I would love to set up a curriculum that actually prepares them to practice law and they'll want to be prepared to practice law because the supervised practice pathway, they're going to have to prove that they've got the skills and the knowledge to be successful and to protect their clients. But right now, we're teaching to a test and to test taking skills, not necessarily the practice of law. And students are sometimes loath to load up on courses. Is this going to help me on the bar? Is this on the bar? Understandably so. And so they lose out on opportunities that could be really fulfilling and also help them develop professionally and personally in more meaningful ways than scoring a 1440.
Or a 1390. Haha. See,
Or
they switched it on you.
1390. Yes, they did.
Although you should go for the 1440 because then you leap over the 1390 and then you are in the safe zone.
Yes. But I think the experiments that are happening in other states are going to be an interesting lens into does it become more inclusive? I think in rural states, South Dakota is considering something you could really get kind of practice in rural states or in rural areas that are legal deserts right now through a supervised practice pathway program. So I think there's benefits on the access to justice side of it, as well as to having a more meaningful entry into the practice of law.
Do you think this decision from the California Supreme Court saying that this is not for California right now will have negative ramifications on what's happening around the country? Or is at this point everybody looking at California and saying, you're so big, you have all these law schools, you have all of these lawyers, I can't really compare myself to you right now?
Yeah, I don't think that California is necessarily seen as a leader in innovation when it comes
That's shocking. That's shocking to me right now.
When it comes to the legal profession. So while I think their decision to jettison the NCBE garnered attention, I don't know that their decision not to move forward with a portfolio bar exam pathway, or at least a pilot of it, is going to necessarily make big waves.
Okay. Well, that's good because I think it's an interesting point that you can practice this in smaller marketplaces. In California's tiny defense, because we've been ragging on the California bar for most of this podcast episode, we are like a country. We have so many people and so many lawyers that they're trying to manage. It is a very different thing. And for those of you who didn't, who are listening to this, if you wonder what it's like to take the bar in California, you go you used to go to these huge convention centers and you would just sit with, thousands upon thousands of people, and the din of the typing is just, it's immense. It's a very unique experience and is very different than the stories I've heard from jurisdictions which just are trying to manage the volume of applicants. So I'll give California that little bit of credit that they have something very hard. If you enjoyed this video, please take a second to give us a like and leave a comment. And be sure to subscribe to our channel so you don't miss any future content. If you have any questions, feel free to reach out to us via the contact form at lawschooltoolbox.com.